Jean-Yves, he is Microsoft's counsel, and he is also a professor at Bruges University. And he is a competition lawyer that I know very well because I was very privileged to work with him on the famous Microsoft case. When I say famous Microsoft case, he thinks of very many cases. I am thinking of a particular given one. But it was one of the very interesting periods of my career where I was about to go back to Turkey. I was determined to go back to Turkey and then to be a part of the Turkish competition law bar. And he was leading the efforts from the European angle, along with a lot of colleagues from the US and elsewhere. And Ian Forrester was in the team. So was Jean-François Bélis, who was here last year as a speaker, you will remember. Jean-Yves and I, we go a long way back, and therefore I know that he's a very engaging speaker. Without further ado, let me leave the floor to Jean-Yves.
Thanks very much, Gönenç. Thanks very much for reminding me of these old stories where we were together fighting a few cases. Thanks very much for inviting me here. I mean, it's an absolutely fantastic audience, and I'm very, very happy to be here to talk to you about a question which has come up recently, frequently, and has received different responses. And the question is whether competition law is the appropriate tool to solve the competition issues, I mean not only competition issues, that may arise in the digital industry, in the data economy. Let me give you a little bit of background to understand why the question is not unimportant, has some relevance. I think that there are really two elements why, for me, the question needs to be addressed. The first one is really the increased importance of the data economy in trade generally. If you look at figures, the figures do not really tell a lot, but digital trade, in the trade of goods, for instance, accounted a year ago for approximately 10% of all trade in goods. It's not much, but the thing is that digital trade is focusing on certain types of goods, and if you look at those types of goods, whether it's music, whether it's books, whether it's hi-fi equipment, clothes or shoes, then you get to a much higher proportion. If you go to services, there you see that digital trade accounts for something like 40%, for instance, of all the trade in hotels and travels and tourism. And so digital trade is something which is already significant in the overall trade, and the growth of the digital trade in the overall trade is something which is really impressive, and which really raised the question, okay, what's going on in digital trade? Are there competition issues? How can those competition issues be dealt with, be addressed? So that's one aspect. The other aspect is about competition issues. When you raise the question whether competition law is the adequate instrument to address the issues that arise in the digital trade, of course, the one question that you need to also confront is, okay, fine, but what are the competition issues? As a company which is very active in that space, I would say, well, there are not too many competition issues focused on other industries. But in fact, if you look, you can really classify the questions which arise in digital trade into three categories, and all of them turn around the role of digital platforms. And the kind of issues that arise are issues that relate to either competition between platforms, competition on the platform, or competition between digital platforms and the traditional trade, the brick and mortar retailers and vendors. Competition between platforms, well, the kind of question that arises relates, for instance, to agreements or to practices that enable one company to accumulate, appropriate, and keep for itself the data which is the raw material. It is the input which is necessary in order to engage in digital trade. So competition between platforms is going to turn, for instance, onto questions that relate to the appropriation of data, or to other issues such as the one that Rainer mentioned this morning on price clauses and English clauses or price parity clauses, call it as you wish, between the various platforms. So that's the kind of competition issues between platforms that is rising today and which is confronting competition lawyers. When you talk about competition on the platform, then you have issues such as, for instance, exclusivity, exclusive clause that could be requested by participant in one platform vis-à-vis all the other competitors in the trade in which it is. Competition on the platform, it can be an issue which the Commission is currently considering. It's the favorable treatment or the different treatment that may be applied by the platform to the various participants in the platform. That's the subject matter of the Google shopping investigation at an EU level. So that's the kind of issue that may arise when you talk about competition on the platform. And then there is competition between the digital platforms and the brick and mortar trade. And we have heard this morning about this kind of issue, and more specifically, in my view, the question whether, for me, that it is really not an easy one, the question whether the rules that have been devised and developed for the brick and mortar trade, whether those rules automatically apply to the digital trade. I was hearing this morning the distinction between active and passive sales, and it's a distinction which is very well known in the brick and mortar trade. Does it apply the same way? Should it apply the same way in digital trade, where essentially all the trade by consumers is passive sales? It's consumers going on the internet, looking for something and being told, okay, you can obtain the good that you're looking for from this and that and that and that vendor. That's the kind of response that you have when you do a search on the internet. And most of the trade on the internet is passive sales. Should we apply the rules that apply, that have been devised for the brick and mortar trade in the same way in the digital economy? It's a question. So, by way of background, that's the 2 points which I wanted to make. It's the increased importance of the digital trade in the overall trade, and the fact that, yes, there are competition questions that arise. Are they frequent? Are they important? Well, let's say there are a number of competition questions, which therefore give rise to that question. Is competition law really the right tool to address those issues in the digital trade? And there, so far we have heard one response, and very recently we have heard another one. And let me talk to you about the two responses, and then I will comment on the two responses. A response that we have heard most often is that, well, competition law may not be the most appropriate tool to address all the competition issues that are raised in digital trade. Competition law may not be the most appropriate tool to address all the questions which are raised by platforms. Maybe we need more than that. So that's one thing. People saying competition law is not the right tool. Very recently, in fact it's last week, in Germany, the Bundeskartellamt adopted what looks for me to a completely opposite decision, or at least it's looking into this in the investigation of Facebook, which is whether competition law should not be used, in fact, to sanction infringements of other laws. And in the Facebook case, it's infringement of data protection or consumer protection laws. Because the question which the Bundeskartellamt is looking into is whether the way in which Facebook engages with users and tells or doesn't tell, as a matter of fact, users what Facebook is going to do with the data of users, so whether this practice of not being entirely transparent, according to Bundeskartellamt, not being entirely transparent with users about the use of data, whether this is an infringement of data protection laws, and if so, whether that can also be, by the same token, an infringement of competition law. And so you have, on the one hand, some commentators who question the adequacy of competition law to address the issues that arise in the digital trade, and on the other hand, you have other, in this case, a competition authority, using competition law to look into violations of other laws. Let me comment on the two approaches. Is competition law the right tool to address competition issues in the data economy? Or do we need a specific regulation? Traditionally, regulators have adopted specific sector regulation where they were facing what's called a market failure or a market imperfection. As a matter of fact, there is at least one type of online platforms for which there is already a specific regulation. It's the computerized reservation system in the airline industry. So that's an industry where you have those computerized reservation systems which enable you to book certain flights according to various criteria, the price, the seat availability, of course, and timetables. In the 1980s, if my recollection is correct, both the United States and the European Commission looked into the use of computerized reservation systems by airlines, came up with the antitrust investigation, and then the European Commission adopted a regulation dealing with computerized reservation system, and therefore that's a specific regulation addressing the kind of competition issues in this field, instead of the implementation and enforcement of competition laws. There is a big difference between the situation in computerized reservation systems and the competition issues that arise in the digital world generally. Computerized reservation systems, I mean, the competition issue was very specific. It was the question, or it turned around discrimination applied by computerized reservation systems that were linked or tied to certain airlines in favor of those airlines. So when you were typing, for instance, flight between Istanbul and Brussels, on the Turkish Airline had a computerized reservation system, and on the Turkish Airline computerized reservation system, you would have listed at the top the flights from Turkish Airlines from Istanbul to Brussels. And the Belgian Airlines, whose name always escapes me, even if it's my country, it's a complicated one, would look at its own flights from Istanbul to Brussels, Brussels to Istanbul, and would rank those at the top. So you had a number of airlines who had their own computerized reservation system, and that were really favoring their own flights at the top of the computerized reservation screens. The European Commission, Department of Justice, looked into that. The European Commission came with a regulation which basically imposes a rule of non-discrimination between the airline which may be tied to the computerized reservation system and the other airlines. You have to rank the results on a non-discriminatory basis using objective criteria, pricing, seat availability, and so forth. That is a specific regulation, but look at it. It's a specific regulation that addresses a specific issue in a specific industry, and it's a specific issue which was such that actually it rendered the product, the computerized reservation system, improper for its function. The whole idea was to have, on a computerized reservation system, a broad availability, the broadest possible availability of all flights that would take you from one city to another. And because all those computerized reservation systems were tied to airlines and were all discriminating their own airline in the rankings, the product itself, the computerized reservation system, could not deliver the goal, could not deliver on the goal that it was supposed to achieve. It needed to be non-discriminatory to achieve that. And that's why the European Commission came in, but in a very, very specific situation where you have a market imperfection, a market failure, which renders the product unfit for its own purpose. Compare this to the digital economy, where, as a matter of fact, you have multiple platforms between a large variety of participants. There are B2B, B2C, C2C. Facebook is C2C, B2C platform. So you have a very broad variety of platforms in terms of participants, in terms of trade in which they are involved, whether it's in social, information, shopping, travel, where you have different business models, some platforms that are making money, monetizing essentially through advertising, those that are selling and taking a fee each time a sale is taking place on the platform or on the participants of the platform. So you have a very broad variety of platforms. And on top of that, you have a pretty broad variety of issues that may arise in the use of those platforms. The issues that I was mentioning earlier before, issues that relate to competition between platforms, competition on the platform, competition between platform and brick and mortar trade. And therefore, this broad variety of platforms and the broad variety of issues that may arise really question, they really question the issue whether a specific regulation would work here, and, because for me that's the key point, would work better than competition rules and the application of competition rules, the flexible competition rules to address those issues. So far, so good. We have applied competition rules. I think Booking.com is an example which may not be the best one, but leaving aside, I would say, more the procedural or cooperation issues that arose in Booking.com, it shows at least that competition law is there and has the tools to address that. Now, Frédéric Génie this morning made a fantastic presentation opening up a work program for the next 2 years to address the difficulties, the challenges that the application of competition rules to the digital sector raises, whether it's in terms of concepts, in terms of tools that are available. I would not deny that there are indeed a number of issues. There are a number of issues. But those issues have been faced in other industries. It's not only the platforms that are two-sided markets, you have two-sided markets in many other areas. Take, for instance, the newspaper industry as a whole is a two-sided market, which raised the same kind of issues. So I'm sure that with the creativity of which characterizes antitrust lawyers, over the next 2 years, we will be able to deal with those issues. But the point here is, there is nothing in the platform world that make it appropriate and which makes the adoption of a specific regulation necessary, as it was, for instance, in the computer rights reservation system. Let me now turn briefly to the other position, the one which has been taken by the Bundeskartellamt recently, which consists in as I said, examining at least, because I think that that's at this stage that we are examining whether a violation of data protection laws by a platform such as Facebook can also be a competition law issue and should be sanctioned by competition law. I think the issue is pretty new, and for me it is a fantastic, really fascinating question. You can see it in two ways. The first one is to, and I don't know exactly how the Bundeskartellamt is looking at that, but my understanding is that the Bundeskartellamt is looking whether the violation of data protection laws by Facebook would be a kind of an exploitative abuse, as we have also under Article 102 of the treaty. So whether it is an abuse of a dominant company against users rather than against competitors. So the Bundeskartellamt, as I understand it, is looking into those practices as an exploitative abuse. If that's the case, I think it goes a little bit against a trend that we have seen over the past 30 years, where competition regulators were really walking. We have exploitative abuse under Article 102 TFEU, as you all know, of course. But over the past 30 years, all regulators have walked away from the implementation and enforcement of Article 102 in that against this kind of abuse, and have really focused on exclusionary abuses. And I think that my personal view is, I think that's right. Because if you call on competition regulators to enforce competition law against exploitative abuses, whether it's, for instance, a violation of data protections, then you are going to confront those regulators with issues which they really want to stay away from, such as, the most obvious one, is this price fair or unfair? What's the best innovation? Is this innovation the one that we should, to which we should give priority, or that one in case of an acquisition between two companies? So if we want to go in, if the idea is to enforce competition law to sanction exploitative abuses, again, my one comment here is we have walked away from that over the past 30 years, and for very good reasons, because I think everybody recognizes, and I think competition regulators in the first place recognize that they're not the best judge for what the price should be, what innovation should prevail, what kind of innovation should prevail, and so forth. And that should be left to the market. Second possible reading of what the Bundeskartellamt is doing is that the Bundeskartellamt, and that is very, for me, a fascinating question, whether the violation of data protection laws, if it is established, which is a point that needs to be investigated, the violation of competition laws gives Facebook a competitive advantage over all other social networks that themselves comply with competition, with data protection. So is it the case that what Facebook is doing, not disclosing everything, not being fully transparent about the use of consumer data, is this a violation of data protection laws or consumer protection laws? And if so, isn't it the case that this infringement gives Facebook competitive advantage, which competition law then could look into and against which it could be applied? Two comments if this were the approach. And one is a technical one and the other one is more policy. At a technical level, my sense is that if we want to go into that direction, we are going to face a pretty significant challenge, which is going to be a challenge of causation. And in that sense, if we want to examine whether a violation of data protection laws is also a violation of competition laws, at some point you need to show that the violation of data protection laws indeed is distorting competition. So you need to measure the impact which this violation of competition law has on the competitive position of Facebook. Well, that is pretty challenging. How are you going to measure the impact which not disclosing fully the information has on the competitive position of Facebook? Number one. Second, are all those social networks all angels except Facebook? Facebook is going to come and defend, hey, wait a second, this is what we are doing, but you know, there are other social networks and they are not really angels. They also violate other laws in this way, in that way. And then how do you balance that? So going into trying to enforce competition law to sanction violations of other laws is, from a technical perspective at least, raising this causation, quantification issue, which in my view is not easy. But the other point is probably more important, is the policy level, is that if we do that, if we use competition law as a tool to sanction violations of laws such as data protection, of consumer protection, I'm afraid that in the future we will see competition law really absorbing all those laws and absorbing all the enforcement resources and enforcement activities of the state, and therefore use competition law to go after a number of other laws. And that's something that, you know, history is interesting here, because we have had that also in European law in the field of the free movement of goods, where in the 70s, you were not yet born at that time, I was. So in the 70s, we could see the Court of Justice had interpreted what is now Article 34 of the treaty, prohibiting measures which have an effect equivalent to restrictions, to quantitative restrictions, as covering non-discriminatory trading and product rules which were not objectively justified. And so there was this very broad interpretation of Article 34 in two judgments called Dassonville and then Cassis de Dijon, famous for those who were studying European law at the time, which I did. And this provision, 34, was so broad, it covered, it could be used to review the legality of any trading rule whatsoever, trading rule, and any rule that related, of course, to the manufacture of products, and see whether those rules were discriminatory, directly, or indirectly, whether they constituted obstacle to trade between member states, and if so, whether they were justified. And what happened is that the court case law on Article 34 became absolutely immense, and that provision absorbed almost all other provision. Every national rule was being reviewed under the test of Article 34, whereas you had other provisions in the treaty, freedom to provide services, free movement of capitals. Those were completely forgotten. Everybody was claiming that the national rules they were challenging were contrary to Article 34. And so and that resulted from the very broad interpretation the court had given to that provision, which the court then came back on with the famous third judgment, which you certainly know because that's current law. It's Kek and Mitouar. So the court had this broad interpretation. The provision absorbed everything, and the court said, okay, no, we can't go on. We need to revisit this interpretation, and then the court narrowed the interpretation of Article 34. It is possible that if we take the direction which I have alluded to, I don't know whether that's the direction which competition authorities are taking at the moment. I don't know whether that's the direction that the Bundeskartellamt is taking at the moment. I'm just saying, I mean, I'm just commenting on this very interesting question, in my view, whether competition law can be used to sanction violations or infringements of other laws which may give the infringer a competitive advantage. So that is, for me, the fundamental question, whether competition law can be used or should be used to sanction violations of other laws, consumer protection, data protection, security, product safety laws, when those violations could give the infringer a competitive advantage. Say, well, in my sense, we need to be a bit careful. It's interesting, it's fascinating, it opens the door to, wow, fantastic avenue. Competition law is a very strong tool to encourage compliance by market actors, but both at the technical and at the policy level, it raises a number of questions and challenges in my view. So conclusion is simple. To the extent there are competition issues in the digital industry, my sense is that competition law is the right instrument. Use it as it has been developed so far. Do not narrow it. Do not expand it over its to cover more than competition in the market. And then, you know, come and work with us on the next 2 years to address all the issues that Frédéric Jean-Yves was listing this morning, because these are the issues that are arising. These are fantastic issues, fascinating issues, and there is work for all of us to address those issues. And I hope that we'll work together to address the conceptual and the tool questions which the application of competition law to the digital industry is raising. Thank you very much for your attention.
Thank you, Jean-Yves. Very engaging, as always. Let me take a minute to introduce two things for you. One is I was waiting for this moment because I knew that Jean-Yves was going to talk about the interdisciplinary issues and whether you can address other policy goals with those of competition law, or rather through competition law enforcement, and a topic that is dear to our hearts with my co-authors is therefore, I think, ripe for introduction, which is another angle of this, and Jean-Yves has discussed a little bit, is the compliance and the interaction within the compliance field. In the folders that you have found on your chairs, you will find some materials and, you know, notepads and whatnot, but you will also find a copy of the Journal of Business Compliance. The Journal of Business Compliance is an international journal that deals with compliance matters, and this edition was reserved to us. We have come up with an international publication on why compliance should be seen as a whole. So basically, we have taken on the topic of compliance in the antitrust field, mushing into compliance in the anti-corruption field. And me and my co-authors, a couple of my co-authors from the anti-corruption specialization and the rather interesting field of white-collar irregularities specialization of our law firm, and some from the antitrust side, we have joined our forces to argue a very basic point, that is, if compliance programs are a mitigating factor in the anti-corruption field, could there be any logic of not recognizing it as a mitigating factor in the antitrust field? the assertion seems to be simple, but we have a long way there. Just in the last ABA spring, Cecilio Madero was making the point that people should feel lucky that this is not being made, the existence of a compliance program is not being made an aggravating factor, and that the efficiency of a compliance program is actually in its ability to stop violations, but it doesn't warrant any independent rewards. That's one way of approaching it. Another way of approaching it is people should need incentivizations. As they always need incentives, they should be further pushed to do a cost-benefit analysis to engage in compliance programs. Our contribution to this debate, and this is a very recent publication, that's why we brought it to you. This was just published a couple of weeks ago. With Joe Murphy's, who is also one of the subscribers of the holistic view into the matter of compliance. With Joseph Murphy's foreword, we tried to make the point that there should be a holistic approach to compliance matters, and there shouldn't be so much difference in handling anti-corruption compliance versus antitrust compliance. I'm making this point right after Jean-Yves because people, at least people in Turkey, know very well that I am an absolutist when it comes to rejecting other goals in the competition law realm. To me, there should only be social welfare maximization. I could accept consumer welfare maximization, but it has to be some form of welfare maximization. And ever since I have written the book that I told you about, I have always advocated that what I called in the book imported ideas of competition law objectives should be rejected. And the Turkish Competition Authority has been doing that quite skillfully, and they have been keeping their eyes on the competition law prize, that is an increase in efficiencies through which you can attain, hopefully, welfare maximization. And they have been tested with very many cases, with health codex issues. Yes, we don't allow them to sell to certain distributors, but those distributors are keeping our products in filthy conditions. And this is leading to a joint and severable liability for the trademark holder, i.e. the producer, i.e. our client, so please let us go. And the Turkish Competition Authority would say, no, this is a whole different matter. It has to do with the health codex. Don't be bringing these goals to the competition law enforcement. Much like that, in the compliance field, we're feeling that there is a very interesting debate going on. So at the expense of taking 7 to 10 minutes of your time, I just wanted to introduce to you that there is this delicious discussion about why should antitrust compliance be so different in its perception and in its rewarding mechanisms by the enforcers when compared to some other compliance mechanisms.